Ladies and gentlemen, good morning, members two of the Public Accounts Committee. We want to begin, as we normally do, with an opening prayer. I will ask Mr. Isaac Rankin if he would lead us in that prayer.
Thank you, Mr. Chairman. Let us pray. Our Father, thank you for bringing us together safely as we prepare for this public accounts hearing. We ask that you prepare our hearts and lead us in your wisdom. May we set aside our own agendas and seek what you desire of us to accomplish during this meeting for the betterment of our country and our constituents. We ask these things in your Son's holy name. Amen.
Thank you, Mr. Rankin. Again, I say good morning to members of the committee and to the general public who might be watching or listening in to the proceedings here this morning. We have had apologies from Mrs. Catherine Ebanks-Wilkes, who is unable to be here this morning. And we are here meeting to examine a report issued by the Auditor General entitled A Follow-Up on Past PAC Recommendations 2022, Report Number 3, issued in September 2022, so just a couple months ago. So at this point in time, I'm going to invite the Auditor General, if she would, to make her opening remarks.
Thank you, Mr. Chairman. Good morning to you, members of the committee, fellow officials and the listening public. Thank you for the opportunity to make some opening remarks. As you mentioned, Mr. Chairman, the report we are considering is the follow-up on past PAC recommendations, Report 3, published in September. That report followed up on 2 previous performance audits, and today's session relates to our 2019 report on the efficiency of summary courts. It is disappointing that almost 3 years after making recommendations, only 3 of the 13 recommendations have been implemented. All 3 of those recommendations related to government. The other 10 recommendations were directed to judicial administration, and they have not fully implemented any of those. It is unclear if judicial administration accepted 1 recommendation, and of the other 9, only 1 is in progress. Judicial administration has plans but has not started addressing 4 recommendations and has made no or limited progress on another 4. For these reasons, we have assessed judicial administration's progress in implementing the recommendations made as red or limited. And the PAC, of course, have consequently decided to hold the witness hearing here this morning. Some of the critical recommendations remain outstanding. For example, judicial administration has not yet established a performance management framework for the criminal justice system. The framework would help judicial administration understand the reasons for adjournments and delays in court cases. If judicial administration had this information, then they could use it to improve their business processes. Secondly, almost 3 years later, there is still no outline business case for the new court building. And judicial administration's progress on producing this is not entirely clear. Some of the recommendations made by my office and the PAC previously need to be implemented to feed into that business case before it is finalised. For example, without considering court users' needs or long-term projections of demand for courts, the outline business case for the new court building will be flawed and will result in a building that is not fit for purpose. Judicial administration is therefore also likely to incur unnecessary costs later on to modify the building, as may prove necessary. I have with me today Angela Cullen and Adrian Morenzi, who supported me in preparing the report, and we are here to support the committee in any way you please. Thank you, Mr. Chairman.
Thank you, Auditor General. I'd now like to call the witness invite the witness into the chamber, Mrs. Suzanne Bothwell. You wanted me to recognize him. Good morning, Ms. Bothwell. Welcome to the Public Accounts Committee and to this hearing this morning. You are going to be questioned by every member here of the Accounts Committee this morning. But what I would ask you to do at the time of your very first question, if you would state your name and title before answering that question, just for us here for the record. So, welcome to the committee. I will kick things off initially with a very short statement, and I do have a couple of questions that I would like to ask before other members take over from me and lead the questioning. It's been 3 years since the Auditor General's report about the efficiency of some records was published. And since then, only 3 of the 13 recommendations have been implemented, and all of these were directed to the government. We welcome the good progress made by the government. However, judicial administration has not fully implemented any of the 10 recommendations directed to it. I noted from the Auditor General's report that it is unclear if one of the recommendations was accepted. Concerning the other 9, only 1 is in progress. You plan to address another 4 but have not started, and you have made no or limited progress for the remaining 4. The purpose of this hearing this morning is to discuss judicial administration's progress with implementing these recommendations, and members will follow up on this throughout the morning. I noted that the government minute, which is your formal response to the previous PAC's report, was not tabled until June 2022 and is dated September 2021. Ms. Bothwell, can you explain to the committee why it took so long to prepare and submit your formal response?
Good morning, Mr. Chairman. Suzanne Bothwell, for the record, Court Administrator and Chief Officer, Judicial Administration. I'll answer your last question regarding the government minute. I'm not sure if I'm getting good volume. I remain unclear as to why the government minute did not come through on time. When I was asked to prepare these documents, I prepared 2 of them. One was dated September 13, 2021, and I did prepare it in September 13, 2021, and handed it over to the person who I was liaising with. I believe it might have been through the DG's office, and I provided that to them as part of what I understood was to be a larger response. I was also approached in this year to provide an updated response in August 24th, 2022, which I did provide an updated response likewise. I unfortunately am not aware of where the process broke down because I responded to the email that I was sent to provide information.
Well, thank you for that, Ms. Bothwell. That sort of dovetails right into with the next question that I have, which really concerns your role and relationship between yourself as Chief Officer and Court Administrator and the Chief Justice and the Deputy Governor. Can you give us some clarity there in terms of that as to what the roles and relationships are between you and these 2 offices?
Thank you. Mr. Chairman, as Court Administrator, I am the head or support the Chief Justice in managing the staff and all operational matters in the Judicial Administration. The function of Chief Officer falls as a result of the Public Service Management Act and my obligations and responsibilities regarding the personnel, hiring, management, termination, discipline, etc., and also any financial obligations under the Public Finance Management Act. Those are where those 2 functions lie. However, on a day-to-day basis, I report directly to the Chief Justice on all matters. I do have to interface with that office on all matters, including personnel and anything to do with expenditure for the courts.
So from your perspective then, on an ongoing basis, is there much interaction with the Deputy Governor's Office in terms of the operations of the courts, recognizing separation of powers?
Not in terms of the operations of the courts. However, with respect to his role as the head of the civil service and any wider government initiative, as a chief officer, I do attend the meetings. I do comply and work with his office to address any concerns that come down from the government, and to deliver any initiative from a civil service perspective. But there is quite a dividing line between the level in which the deputy governor can give directives or make decisions for areas that fall within the Chief Justice's purview as head of the judiciary and head of the administration.
Okay. Thank you very much. Auditor General, I believe you may have a question.
Thank you, Mr. Chairman, and through you to the witness. Mrs. Bothwell's just explained about the government minute being submitted in September 21. The question I'd like to ask is, submitting in September 21 was already a year late. So our report was 2019, PAC had their hearing. We're required by law to have a government minute laid within 90 days. And so this was due in October 2020. So through you to the witness, I just wondered if Mrs. Bothwell could say why, even at September 2021, it was nearly a year late in being submitted. Thank you.
Ms. Bothwell.
Thank you, Mr. Chairman. I have to confess I was not aware that there was a deadline. If there was a breach, that would have been entirely my fault. However, I was requested to do one for 2021, and it wasn't made, the request didn't come to me from the Auditor General's office. I do not believe that first request came from that office. I believe it came via the Deputy Governor's office. So my understanding was that I was contributing to a larger document. So if there was an oversight for the initial report, it would have been, I suppose, on my part.
Okay, thank you, Auditor General. We are going to move on then now to the first line of questioning, Ms. Bothwell, and that concerns performance, a broad topic there of performance. And for that, I'm going to call on Ms. Barbara Connolly, who will lead the line of questioning on that. Ms. Connolly.
Thank you, Mr. Chairman. Through you to our witness, good morning, Ms. Bothwell, and thank you for agreeing to attend this public hearing today. We really appreciate it. Okay, I will start my questioning by the first header, which is Performance Management Framework. In 2019, judicial administration did not have a performance management framework to monitor or measure summary court performance and where improvements could be made. To be clear, by that we mean a framework to measure the performance of administration of the judicial administration unit you lead, and not how the judiciary have administered justice. The Office of the Auditor General recommended that judicial administration should develop such a framework. We noted from the evidence you gave to the committee in February 2020 that you acknowledged the need to develop and improve performance management tools. You plan to achieve this through advancements in technology. In the government minute, you reported that several actions were underway or planned. However, it is not clear how you will contribute to developing a performance management framework. We note that you did not provide an update on these actions in August 2022, and so we would need clarification on any progress. So my first question is, Can you advise this committee of what progress, if any, has been made in developing a framework for measuring judicial administration's performance, and specifically for summary courts?
Through you, Mr. Chair. I first wish to perhaps frame my response by saying that the recommendation of the Auditor General's office is for the adoption of the International Consortium on Court Excellence Framework, which I believe was developed in around 2007. That framework is a recommendation to courts, and it speaks to the fact that the architects of the framework encourage government courts to adopt it and to go through the journey of the various specific areas of court excellence. I preface that by saying that this is perhaps is a very comprehensive framework, but it is not the only framework, and it is not the only way in which courts provide performance measures for efficiency and effectiveness. There are processes already inherent to a court system. Its practice directions, its processes, and its court rules. And so therefore, from a year-to-year basis, the Chief Justice or the Office of the Chief Justice or the Rules Committee develop rules to govern the management of court cases. I have reviewed the broad areas of the Court Excellence Framework, and whilst the judicial administration or the judiciary have not yet fully adopted the framework, there are elements of the framework that we are well underway in proceeding with. But I don't wish to belabor that point. The fact of the matter is that the recommendation was made in the report of November 2019, and the complaint or the concern of the Auditor General is that we are 3 years in and it has not been formally adopted. I sit here as a creature of instruction. So all I can say is that I have consulted with the new Chief Justice, Chief Justice Ramsey Hale, who in her opening swearing-in speech did indicate her intention to adopt the framework. However, it was not as if judicial administration refused to adopt the framework and did absolutely nothing and did not take on board any of the recommendations. I did prepare and provide 2 minutes, and I will see to what extent I can encapsulate my earlier responses today. But what happened between 2020 and 2022, a lot of activity has happened between those 2 years. First, I wish to state that in the beginning, the first quarter of 2020 was a pandemic. So, but after coming out of the Christmas season, not even completing the first quarter of 2020, judicial administration, like many government entities, had to pivot. We did not have the ability or the wherewithal to close, because judicial administration is in fact an essential government service. So we operated throughout the entire pandemic, and we had to find a way to meet the needs of their court users and to provide access to justice in an ever-changing environment. Those activities which allowed us to operate consumed all of our resources, human and otherwise. Some of the things that we had to do was immediately at the end of March implement a slew of COVID practice directions to allow the courts to operate in an environment where we had 24-hour emergency lockdown. We still had to process prisoners. We had to process people who were in custody. We had to get all of our judges and courts up and running virtually. We also had to make sure we received maintenance funds for families. We had to find a way to ensure that clients were able to receive their maintenance funds online. Thankfully, from the efforts of our finance team and our chief financial officer, we had in fact implemented a relationship with Royal Bank and the Cayman Islands government to allow for those direct transfers to commence in October 2019. So we did in fact have a framework where we could pivot very easily, but there was tremendous effort in trying to get our clients to on board so that their checks were not left in the post office, they were not able to access them, but they were able to use their debit cards because we had put the funds into their office. And those things take time and they took effort by all of us, particularly the Chief Justice and the management of judicial administration. In addition to that, we also had to fast track our implementation of our court database. I don't know if you are aware what it takes to actually launch a new court database, or not a court database, but any kind of database, any kind of new function. But that took time, and we actually had to fast track whatever we were doing to allow for online filing of court documents. And I would just like to say that it is through the continued efforts and the priorities placed in 2020 into 2021 that Cayman was one of the only courts operating fully in 2020. And we actually started jury trials in 2020, therefore attacking aggressively any case backlog issue in our Grand Court. And that is an issue that a number of courts currently are tackling globally because they were not able to accommodate in-person hearings in their courts and jury trials. But none of these things are excuses. It is just trying to lay the landscape of the activities and the priorities that the organization had to focus on in 2020 and 2021 to administer justice in the Cayman Islands. We also had to start catering in 2020 to our international court users and our financial firms. We even held remote Court of Appeal hearings. I don't know if you recall that we live streamed cases of national importance over our internet so that the public who could not physically come to the court could still see justice in action, could participate in justice, whilst our entire panel of the Court of Appeal resided in their jurisdictions in the United Kingdom. Those are the kinds of activities that we had to basically pick the court up from scratch in order to operate in a new and dynamic way. So to say that the introduction of the ICC framework unfortunately did not match the priority of trying to get the courts to operate in a pandemic is perhaps a truth. It fell second. But notwithstanding that, the Chief Justice did in fact at that time implement a number of court rules as a means of continuing to introduce efficiency and effectiveness in the court system. In 2019, he introduced the criminal court procedure rules. In 2022, he introduced rules regarding listing. And it is during 2021 and 2022 that we have been focusing on the rollout of our database. I have looked at now that the new Chief Justice is in place, my understanding and my instructions are that she finds herself in the position to bring effect and to launch the ICC framework for 2023. That is part of her mandate. It covers a number of broad areas such as court leadership, strategic court management, court workforce, court infrastructure proceedings and processes, court user engagement, affordable and accessible court services, and public trust and confidence. It will launch, I understand she's going to raise it at the Grand Court opening with a kickoff for February of next year. It is clear that it will be a multi-year initiative because this type of initiative will require major stakeholder engagement. It will also require potential legislative changes and also conversations with the executive arm of government regarding any financial implications of introducing the framework to its fullest extent. So we recognize that this is not an initiative or a framework that can be taken on half-heartedly. It cannot be taken on without the appropriate human resources to dedicate to lead it. And certainly the commitment is there to initiate it in 2023.
Ms. Bothwell, you're speaking a bit too close into the mic for us. It is getting a lot of reverb.
Okay,
so
let's see if that will
just
be
bear
better.
that in mind as you answer the questions. But thank you for that. There was a lot for us to digest there with what you had said. But Auditor General, I do believe you wanted to pick up on something.
Thank you, Mr. Chairman. It's just I wanted to clarify and correct something the witness said. We did not recommend that they adopt the International Consortium for Court Excellence framework. We merely recommended they adopt a performance measurement framework. It could be far simpler. We did look at that framework because that's a global standard and we considered it in our report. But to be clear, we did not recommend that they adopt that. It's not for us as auditors to say what performance measurement framework anybody should introduce, merely that they need some performance measurement.
Thank you for that clarity, Auditor General.
Sorry.
Ms. Connolly?
Mr. Chair.
Yeah, go ahead, Mr. Seymour.
Thank you and good morning to everyone. For my edification, I just wanted, and please bear with me, I detest doing this, but I just wanted, and I'm grateful for the honesty and admittance from Ms. Bothwell. But she answered earlier that she didn't know there was a deadline for a report. And I, for my edification, I just wanted, in terms of the 90-day compliance, and I wanted to try to understand either from the Auditor General or from the FS as to, is there a handbook or where is this found that persons would know these guidelines? That's my question.
Auditor General.
Thank you, through you, Mr. Chairman. It's a requirement of parliamentary standing orders that once a report's laid in the table of the House, a government minute is laid in response no later than 90 days. Clearly, with the House not sitting frequently, that can be problematic. But when we do our follow-up reports, we always report to this committee on how long after the date the minutes are tabled, and generally they're considerably in excess of the 90-day standard. And as I said in the follow-up question there, originally the response was due in October 2020 for this particular report. Thank you.
And for benefit, your benefit as well as that of the public too, Standing Orders, paragraph 77, subsection 77, subsection 7 states that the government minute shall be laid on the table of the House within 3 months of the laying of the report of the committee and of the report of the Auditor General to which it relates. Ms. Connolly?
Thank you, Mr. Chairman, through you to the witness, and thank you for that full explanation that's you were able to confirm some of the questions that I was going to pose. But can you provide some target date for the full adoption of this court excellence framework that you have suggested, that you all are actually working on?
Through you, Mr. Chair, I believe that in my earlier response, I did indicate it will be a multi-year initiative. My limited understanding of where the Chief Justice is going is that she believes she will have to have that stakeholder engagement first to decide which one of the framework areas are going to be adopted, for example, in 2023. It is not expected that it will be done at the same time. I looked at the framework guide that was provided by the entity, the owners of the framework. And one of the things that I noted is that it calls it a journey, that it is expected to be a journey for courts, because it is really looking at every aspect of court, delivery of court services, and certainly it will take time. We expect, I can say that one of the priorities of the Chief Justice is to review and look at the area of costing of cases, something identified by the Auditor General in one of the recommendations. So she has identified that as at least one of the early areas. And certainly judicial administration, in working with our partners to develop the platform, we would be in a position, because the platform is partially launched and we have started work on our analytics, is that we would be able, I believe, in the year 2023 and perhaps the first 6 months of 2024, make good headway in developing analytics from a whole court perspective, not just the summary court, because our platform is actually live in our non-criminal divisions, and we are working to really build out the criminal portion of our platform with our, I think it's about 20 plus stakeholder groups on the criminal side. And so what I expect is 2023, we would be able to actually start looking at costs, working with an expert who can help us understand how to calculate costs for a court case. So that was the best way to go about that. And with a view to rolling that part of the analytics out for all of the court divisions. So whilst I think 2023 would be a very productive year in that respect, I wouldn't be surprised if we do go into 2024, given all the divisions of the court that we'll be working on. Other than that, I would have to defer to the Chief Justice's statements in the Grand Court opening speech about what her intentions are.
I just have, it wouldn't be clear to me, Ms. Bothwell, but I think you may have addressed it. I just don't remember, so correct. I don't mean to double ask questions, but the summary court case management rules, that the government minutes specifically stated they would be implemented by the end of 2021. Did you say that, are they now in effect?
Through you, Mr. Chair, I can provide an update on the case management rules for the summary court. In further consultation with the chief magistrate, I have been advised to update the Public Accounts Committee, and clarify a number of issues regarding summary court case management. Firstly, whilst the case management rules implemented for the Grand Court in 2019 have been were implemented in September 2019, they do apply to the summary court, and it is my understanding that they apply them. I was also asked by the Chief Magistrate to inform the Public Accounts Committee that the summary court actually has its own case management rules that have been established since 2015 through Practice Direction 5 of 2015. And those are what have been applied since then for the governing of summer court cases, which is quite a distinct court from the Grand Court. I've also been asked to advise that the Chief Justice has also implemented, and there have been gazetted, practice directions on listing and custody time limits in criminal matters as part of active case management for both the Grand Court and the Summary Court. And that can be found at Practice Direction 1 of 2022. And so it is a suite of rules that the Summary Court applies to actively and proactively manage summary court cases. I have been asked to refer to a consultancy report that was prepared for the benefit of looking at the summary courts in the criminal area of the jurisdiction of the courts. And it was stated by Justice Toomey and Mr. Ben Yallop, who were the persons conducting the review of those areas, I believe in 2020, I can't remember if it's 2021 or 2022. It's been a while. I'll have to clarify that, sir. That today they did not see any major backlog to speak of in the summary court, and the summary court was sufficiently able to list trials as soon as the case is ready. And they thought that this was something which very few jurisdictions can offer. I have been asked by the Chief Magistrate to advise that in 2020, 102 cases were filed and 93 were disposed, and that was the Cayman criminal courts. They were disposed, meaning they were dismissed or sentenced, etc. And they effectively had, on average, a 91% disposal rate at that time. In 2021, that increased significantly. And certainly in 2022, the summary court continues to make strides in proactively and effectively managing its caseload. Also, with the coroner's court, with the work of the coroner and increased engagement with justice partners such as the RCIPS, they have been able to significantly improve their disposal of coroner's cases. I'm more than happy to provide the statistics to the Auditor General if she requires them for any further information. With respect to the summary court criminal, I am advised that the disposal rates were quite promising to the extent that they had increased from 83% to 138%. And the first half of 2022, the rate remains high, at on average 106%, meaning that they are clearing not only what comes in on any given year, but any backlog from the year before. They're making inroads into backlog cases. I'm also advised by the Chief Magistrate that his office actively monitors what we call cracked or ineffective trials. Cracked trials being those that fall apart for whatever reason, and ineffective meaning that for whatever reason these cases cannot proceed or are adjourned. And this is something that is not only managed by his office, but is also managed by each of the magistrates who oversee trials as part of their case management process. The Chief Magistrate has also asked that I communicate that he has regular engagement with the Director of Public Prosecution's Office. The DPP, as you will be aware, brings pretty much all of the cases that come before the courts. So certainly they are key justice partners. And he also states that there are a small core of private defense attorneys who are trying to form an association to have a single voice for the defense attorneys, and therefore his office is certainly continues to work with them individually, but he looks forward to being able to speak to the defense bar as an association, which is reflected in some of the other divisions of the court. There is also Mr. Chairman, the court uses committee, which comprises of the Office of the Director of Public Prosecution, the RCIPS, Defense Counsel, DCFS, meaning Social Services and Counseling Services and Probation Services. And they actually meet quite regularly and discuss areas of case management, anything that affects any of the justice parties as it relates to the courts. As we develop our court database, we have put in place interim measures in the courts and with our justice partners to enhance court performance, court efficiency. And one of those is that we have adopted as an interim measure a platform, a program really, where the magistracy can schedule their cases, and we actually share that with the Director of Public Prosecution's office, so that if there are any changes, if there's anything to be flagged, that office actually has representatives that have access to the cases, and that quick decisions can be made to reduce any potential delay in completion of hearings.
Okay. Thank you, ma'am. Ms. Connolly.
Thank you, Mr. Chairman. I'm moving on now to measuring efficiency. And my question to the witness is, in 2019, the OEG explained that cost per case is one of the global measures of performance that can be used as a proxy for measuring the efficiency of processing cases. However, the OEG reported that judicial administration had not done any financial analysis of the costs involved in processing cases through the summary courts. Without this analysis, it was difficult to determine whether judicial administration was using its resources efficiently and effectively. From your responses, it is unclear if you accepted the OEG's recommendation 5 to identify the current cost of cases processed through the summary courts. My first question is, can you indicate whether you have, in fact, accepted recommendation number 5?
Through you, Mr. Chair. Before today, I have not been able to give an answer regarding the acceptance of that recommendation, but I can confirm that in consultation with Chief Justice Ramsey Hale, that will form part of her court performance measures.
Thank you, Mrs. Bothwell. Can you indicate how judicial administration measures efficiency without any information on costs?
I wish to perhaps preface my response by saying the costing court cases is a fairly new feature globally as a measurement tool for court efficiency. And so it would be unsurprising to me if this is something that few courts are doing, some courts are discussing, and other courts are not even thinking of. But certainly on our end, my instructions are that we are to proceed to introduce a cost analysis. However, even without those instructions, I would say that by the development and the creation of our new platform, which an inherent part of that is the development of an analytics portion to that platform, that it puts us in a position to be capable, to actually deliver this. The platform that judicial administration operates under is, I think it was implemented in 1990. It is no longer supported by any developer. It is now to be retired. Therefore, that is why we have been prioritizing rolling out our new court platform and making it fit for purpose for where the court wants to go in the future. And that has been one of, I think, 3 priorities that we have had to undertake between 2019 and 2022, the other 2 being pandemic transition. And I was tasked with building 2 additional courtrooms, courtroom 8 and courtroom 9, the last just being completed. So if one looks at the caseload of the summary court, there is no way in an old system that cannot be modified, there's no way manually for us to deliver this recommendation without major innovation in terms of our technology. So in answering this question, I would say that we have been putting in the groundwork. We do have a working platform. It is not complete, but it is working. It is something capable of introducing cost analysis once we know the parameters that we are to be using. And certainly with the introduction of the framework and the work that will be required to deliver that, I am confident that is something that we would be able to execute successfully. But the notion that this is something that all courts are doing and it's a standard practice is far from reality. Globally, courts are at different phases in the journey of any new and modern framework for court performance, because court performance is an ever-evolving matter.
Thank you. Through you, Mr. Chairman, to the witness. So are you saying then that you do have plans then to include the cost of cases in the court excellence initiative?
Sorry, yes, through you, Mr. Chair, yes. That will be part, my instructions are from the Chief Justice, that will be not just part of the work to be completed through the ICC framework, but it will be one of the early areas that we will start in 2023.
I guess then the follow-through question I would have, apart from the cost, then are there other qualitative and quantitative measures that you might be using or have adopted that would assist you in measuring your efficiency of the courts?
I think the biggest and ultimate output of a court is its clearance rates. To you, Mr. Chair, is its clearance rates. And that is something that the Chief Justice speaks at every Grand Court opening. All of our speeches are published online. And that is something that the Chief Justice speaks on. There are a myriad of factors that would affect clearance rate in each type of case that comes before the court. For the purposes of this hearing, we are focusing on the summary courts. But I wish to say that whilst we can do costings, whilst we can have good data on our clearance rates, that information tells us how much it's going to cost to do a particular case. The information might tell us why it costs that much, but the cost on one case might not necessarily have any bearing on the cost of another case, because each case is unique, each case is different. There are a number of factors that one has to consider that could affect a clearance rate in a case. Simply put, we have to look at the division of the court it's in. So if it is a bog standard traffic case, then it shouldn't be too complex. You should be able to get that over with a couple of hearings. However, if the person has issue paying, the court may have to adjourn to give them time to pay, unless the legislation is changed to allow for a different model of payment to be introduced, where these category of persons don't actually come into the court at first instance. If it is a rehabilitation court, this is not about charging a person and then putting in a plea and then they, are sentenced. We are dealing with underlying psychological problems that influence the decision or influence the criminal behavior of an individual. So therefore, it may very well be that this person is before the court for a year, coming back for a number of mentioned dates to see what their progress is, having reports from the probation officer, DCFS, the mental health counselor, psychological reports. Each case that comes before the court is different. So that is why when I started my evidence, I spoke about the fact that courts have a number of rules that the Rules Committee establishes. It has a number of practice directions which provides guidance to both the practitioners and also the judiciary on how to manage different types of cases and the stages of different types of cases, right? We also have to consider too the rights of the individual, right? In our jurisdiction, if a person cannot afford an attorney and it's a case that qualifies for legal aid, then they're entitled to be legally aided. And they're entitled to advise their counsel according to what is in their best interest, right? And if they ask for a number of adjournments and there's a good cause, in the interest of justice, the court has to weigh whether this is an appropriate time to permit the adjournment or not. So, yes, our platform, we are looking to introduce things like the number of adjournments. Those are things that we would have to do digitally. We cannot manually, we have them recorded, but we cannot run the analytics on all of the summary court cases manually on adjournments alone. And we need to ask ourselves, what is it that we're asking? What is this data supposed to be telling us that would either change how we run our business or not? All of these things need to be considered. But what I can say on a case-by-case basis, each of the magistrates in the summary court are very conscious of the court time. They're very conscious of the limited defense counsel resources that are available to the justice system for actually cases coming before them in a timely manner. Because the same counsel who are coming before the summary courts in criminal cases are the same counsel who are appearing in the grand court to do indictment trials. And we run 2 indictments at a time every single week. So there are competing human resources at stake, which will impact the efficiency and effectiveness. The introduction of technology will help. The cost analysis will help. Will it be a panacea? No, it will not. But it will help to inform the strategy of the court. It will help to inform any changes that need to be made, any areas where we see risks are high, and there may need to be an opportunity to revisit how business is done in an area or to engage with stakeholders if there are external factors that affect efficiency and effectiveness.
Ms. Conley, any more further questions? Any other questions from the members on this section? If not, then we're going to move on to the second line of questioning, and that has to do with out-of-court disposals. And for that, I'm going to turn to Mr. Seymour to lead that line of questioning.
Thank you, Mr. Chair. And question is as said, out-of-court disposals. I put this to Chief Officer Bothwell. In 2019, the Office of the Auditor General reported that there were no formal systems for out-of-court disposals, and this lack of early intervention to prevent court appearances is both costly and ineffective. The Auditor General's office recommended two actions: that the judicial administration work with others to monitor and evaluate the use of out-of-court disposals, and that the judicial administration work with others to increase the use of out-of-court disposals if they are deemed to be efficient and effective. However, from judicial administration's response in the government minute, it is not clear if the first part of this recommendation has been completed. And my question is, and before I even ask the first question, I think it may not be as clear to the public as to what out-of-court disposals are. And if you could do so in explaining that the public understands what we're actually doing with this system as an important tool in addressing early stages of offending or behavior, and allowing police to deal quickly with low-level offending without recourse of the courts. My first question is what is the action taken by the judicial administration to work with others to monitor and evaluate the effectiveness of out-of-court disposals that are already in use?
Thank you, Mr. Chairman, through you. It seems to be, particularly on this recommendation, that I do not believe that the Auditor General's Office and Judicial Administration have a shared understanding of the role and function of the courts in out-of-court disposals. In my two responses, I did indicate that really this was not within our wheelhouse, that if it was that out-of-court disposals was to be introduced in any formal way, that there would need to be some form of legislation that would have to be introduced by the legislature. And to that extent, the judiciary or the Chief Justice should be invited to give input on what the Chief Justice believed the role or not the role of the courts to be in out-of-court disposals. That was reflected in my, in my 2021, September 13, 2021 minute, and once again in a much more abridged form in my August 24, 2022 response. And I hope that through this evidence and that through these proceedings, we can perhaps bring this particular recommendation to rest, as I will be asking that it be removed as a recommendation for judicial administration to comply with. Giving the historical context, coming out of an excerpt of the 2015 report of the Criminal Justice Advisor on the topic of out-of-court disposals, and they are what they say they are. They are disposal of any matter outside of the courts, so it never comes to court. The report stated out-of-court disposals. At present, there are two options for case disposal: prosecution or no further action. This leads to minor cases being charged and people unnecessarily acquiring criminal records which damage their future employability and ability to travel overseas. It also increases the volume of cases through which the police, ODPP, and the courts which could have been dealt with in another way. Recommendation A, an out-of-court disposal scheme should be implemented. The use of cautions, conditional cautions, example, payment of compensation for minor criminal damage matters, and youth cautions. These disposals could be recorded on appropriate registers. Any scheme for out-of-court disposals would be, and our view is any scheme for out-of-court disposals would be implemented and executed between the police and or the Office of Director of Public Prosecution. By way of illustration, it is a matter for the prosecution and the police in the United Kingdom under Section 37A of the PACE, or Police and Criminal Evidence Act 1984, equally in the UK, not a matter for the courts. And some of the provisions state as follows. In determining whether to offer a conditional caution in any case authorized, persons and relevant prosecutors must follow the Code of Practice for Adult Conditional Cautions 2013 and comply with its guidance. This guidance assists authorized persons and relevant prosecutors, in brackets, the decision makers, to apply the Code of Practice on adult conditional cautions in deciding how an offender should be dealt with when it is determined that there is sufficient evidence to charge an offender with an offense and the public interest in the case may be met by a caution with suitable conditions providing reparation to the victim or the community, which may modify offending behavior, ensure the departure and non-return of a foreign offender from the UK, or provide the appropriate penalty, and in all circumstances of the case, a conditional caution appears appropriate. This guidance specifies that the offense and the circumstances when a conditional caution may be considered, and whether the decision to offer one may be made by a police officer or is to be referred to a prosecutor. The practical arrangements for recording decisions in cases, consulting with the UK Border Agency, making referrals to prosecutors, and for dealing with non-compliance with any conditions. And this is but an extract of the PACE Act. So when our original response in the government minutes was that bespoke legislation would be needed, this is what we meant, that first and foremost, an out-of-court disposal is axiomatic. It means it is a disposal of a matter which has nothing to do with the courts, right? It is managed elsewhere, right? The court is only triggered in our jurisdiction when charges are laid. And if charges are laid, that means it is an in-court matter. So there's absolutely nothing, whether through protocol, agreements, or legislation, which invokes the jurisdiction of the courts to be involved in such a procedure. Our recommendation is that if the Auditor General believes that out-of-court disposals is a useful tool for the efficiency and effectiveness of the entire justice system, and I do refer to the comments made by the Justice Advisor that right now we have two options, prosecution or not, which means that a lot of petty crime is coming into the court system where there is potentially another way of dealing with it. So if it is still the opinion of the Auditor General's office that in terms of efficiency of and effectiveness of justice in these islands, that we should introduce something similar or introduce a mechanism for out-of-court disposals of criminal activity, then we recommend that, first and foremost, that it be removed as a recommendation binding the courts from being the owners, because it's really clear, even from the UK Act, the court is not the owners of this, and that this is perhaps a discussion that may have to take place under the umbrella of, let us say, with the Commissioner of Police, the Attorney General, under, national security, etc. And then perhaps some sort of instructions be given, whether to the Law Reform Commission to investigate the issue, to see whether something like this could be implemented here. But it would not be for the courts, for the judiciary, to monitor or to have oversight. There is clear separation of powers here, and this was meant to be a tool in the prosecution and the police's toolbox to prevent matters from coming into court.
Mr. Chair, I thank you, and I thank Mrs. Bothwell for such a comprehensive answer. And I know what you said, and all you said, not within your wheelhouse. And I want to ask a question. I don't know if they have the answer, but it kind of leads to, I would think, in terms of the success rate in cases that we bring to the courts. I don't know if you have the percentage, but that would kind of lead us on to believing that a tool of this magnitude would be helpful.
Through you, Mr. Chair. Sir, no, we do not, whilst we do record the pleas, we do not actually measure that kind of data at this time. But certainly, I do believe that the public office holder best placed to provide feedback and perhaps their opinion on the usefulness of such a tool would be the Director of Public Prosecution.
Mr. Chair, I thank her for her answers.
I do have one I wanted to ask, pick up from with it. I mean, so it is clear that this recommendation has gone nowhere thus far, and I think you have said you don't think it's your responsibility or your wheelhouse. But certainly, having made the recommendation, it would appear to me that the court that it has been accepted. I mean, couldn't you, as Chief Officer Champion, try to get this thing to move forward? Whether it needs to have the discussions with Chief of Police or DPP or Attorney General, whatever the case might be, because it will take someone within, I recognize, within the public service or the civil service and the legal system in there to draft the appropriate bespoke legislation that's going to be needed. Your comments? Auditor General?
Chairman, could I build on that because I think it's relevant? Recommendation 9 talks about government setting up a senior strategic justice group that includes the chief officers from all organisations involved in delivering criminal justice in Cayman. That recommendation was accepted, and if we accept what the witness says, which I understand it's not fully for the courts, then I would argue under recommendation 9, which has been accepted and accordingly implemented, that group would be the group that would take forward those discussions and the need for that legislation. Yeah. And also just to clarify that there is reference from judicial administration in other responses that they already use the out-of-court disposal process, which is why we believe there was already an existing process. And we absolutely agree that if you want to extend it, you'll need further legislation. But to build on your point, if it's not for judicial admin, we would hope under the recommendation 9 about that broader justice group, that would be the group that could take that on. And so perhaps the witness could talk about discussions at that group. Thank you.
Through you, Mr. Chair, I hear the Auditor General, and I do take note of her views that this group perhaps could be used as a tool to move such an initiative forward. But understanding the way that the civil service works and who have ownership of certain matters, certainly this matter cannot be led by the judicial administration. It cannot be led by the Chief Justice, because anything that judicial administration does, it does on behalf of the Chief Justice. Fundamentally, this is about the discretion of the RCIPS and the prosecution. The Director of Public Prosecution has an independent function. So there should be nothing to intrude on that decision making, right? It is a matter for that office to make a determination. If there was some form of scheme to make a determination of what comes before the court and what should not come before the court really should not be involved in anything to do with that area of decision making. Additionally, any scheme, at best, the court is a stakeholder. At the highest level, we are a stakeholder, whereby the judiciary and through the Chief Justice should be able to give input as to the benefits this would have with respect to the entire justice system, the extent to which it will alleviate pressure on the court, the positive impact it could have, for example, on judicial resources. Yes, that kind of information, I believe, would be useful and can come from the courts to aid in any wider policy decision making about whether or not to adopt something like these provisions in the PACE Act. But certainly that is very different from using a user group that is meant to engage with the courts on matters that concern the courts to deliver and to push an agenda or a policy on out-of-court disposals, which really should have its own owner. I won't doubt that it may come up. It may be an agenda item, a topic for discussion. But certainly, I still do not believe that this can be a deliverable that should sit, and that can in fact sit under judicial administration, right? And I am asking that this particular recommendation be revisited and removed from this particular audit outcome, because there is likely to be no movement on it if it continues underneath us. I've consulted with the Chief Justice on this quite extensively, and her views are quite clear that the owner is elsewhere, and that perhaps it is for the at cabinet level, whether mandated for the Attorney General to look at this in discussions with the ODPP and the RCIPS for one of those entities to take the lead on something like this, and the court at best will provide input and as a stakeholder.
But, Ms. Bothwell, just I've heard you say it, I think more than once now, requested it be removed. And I mean, practically speaking, that's not possible now, because I think the opportunity for that to have happened would have been the point when the report was first released in draft form, maybe 3 years ago. There was a chance to engage with the Auditor General and whatnot, but it's been the report has been through an agreement process whereby there have been discussions and opportunities for those who the report speaks to respond to in response to the recommendations. And it's been accepted by the government as far as we see here. And there's been, you know, there's been a response. It's been tabled in the House. There's been a minute. Everything else, we're just doing a follow-up to understand what has transpired and what has happened to the recommendations that have been made, whether progress has been made. So that's realistically, that's not possible at all. Auditor General, did you have something else you wanted to add to that?
Thank you, Mr. Chairman. But what we could do is consider the recommendation that may want to come from the Public Accounts Committee. I think we never intended that recommendation to put the full ownership on judicial admin. It says very clearly with justice partners. And in 9, which recommendation 9 about the strategic justice group, we talk about that being the recommendation 9. We talk about that being potentially the group to take that work forward. Ms. Bothwell referred to the court users group. We aren't talking about an operational group. We're talking about a strategic leadership group. And my question was, has that group met? And that would, in my view, be the group to take that work forward, accepting absolutely what Ms. Bothwell says, that it's not, you know, it's not solely for the courts. Of course it's not. So that was the question, but the way round it may be for the Public Accounts Committee to make a slightly different recommendation. Thank you.
We'll take that on board, and thanks for that, Auditor General. Mr. Rankin? Mr. Seymour?
Mr. Chairman, I do wish to state that I did provide an original management response when we received the draft report. And I did say that this was a jurisdictional point, right? It was a jurisdictional point, as there is currently no requirement or legislative or other requirements for justice partners to report out-of-court disposals to judicial administration. I understand and I agree with the Auditor General to the extent that conversations may happen at this level, but I still do not agree that any chief officer group sitting under the court should be leading this initiative. It has to have a driver outside of that entity. Whilst we can get feedback, we can use it as a tool for feedback and engagement, that is fine, but the driver must come from elsewhere.
Mr. Chair.
Mr. Seymour.
As a final comment, and I hear the discussion and appreciate it very much. In my humble opinion, I think it is an important tool for any country. As an outside driver, I guess one of the things, as suggested earlier, and could be possibly done at a later date, in terms of bringing the political arm, trying to bring a motion or something to get this ball started. So that's one of the thoughts here. But I think that the conversation shouldn't go away, and this should keep alive and be done as soon as possible.
Thank you, sir. Any other questions then on this section? If not, then we will move on to the third area of questioning, and that involves IT systems. And for that, I'm going to turn to Mr. Isaac Rankin, who will lead the line of questioning.
Mr. Chairman, thank you so much. Ms. Bothwell, thank you for appearing before us this morning. The Auditor General's report that's in front of us that we're discussing this morning had reported that judicial administration was in implementing the major upgrades to the IT systems, GEMS. It did indicate that there was no business case for the replacement system among the GEMS, and had recommended that the Judicial Administration develop a risk register, change management plan, and a relevant success measures for the new system that would, in a sense, demonstrate value for money. In February 2019, I think you gave evidence where you emphasized the need for a new IT system and a court database and how important these were for the organization, and I do not disagree with that. And you also indicated that at that time that the improved performance measurement tool depended on this improved technology. It is our understanding that you've discontinued the Amanda GEMS project, and thus we ended up writing off $75K cost of the upgrade. And we also understand you're now implementing a new court database system called Curia. And at the end of December, the budget, the spend was $125,000. So could you briefly give us an update on that particular implementation and include a target completion date, and also an update on the cost to date and the expected final cost for it?
Through you, Mr. Chairman. The Curia initiative was an open procurement, a public procurement solution for court platform, and I believe the bid amount was around 700 and something thousand. We had gotten a number of bids up towards to 1.5 million, I think, or 2 million. But we did, in fact, settle on this platform. To date, through the information provided through our finance office, we have spent excuse me for a second. Just want to make sure I get it. Yes, we've spent, I believe it's $287,400 US so far. Where are we? Well, in 2021, we started working on upgrading our IT environment because we recognized that to introduce such a platform on an IT environment that was almost 20 years old was not possible. We consulted with Ms. Pamela Green, who works with the cybersecurity oversight. We had extensive discussions with her, and we also worked with some IT experts and got a report actually to have an understanding of the state of our IT environment and what we needed to do just to even introduce such a platform. So what we have been doing are two things. We have been developing the platform, and secondly, in a parallel manner, upgrading our IT environment to introduce it. I'm happy to say that in 2021, we successfully ran a pilot of the electronic filing in our financial services division in partnership with a number of law firms. And that was the model through which we were able to roll out successfully this year electronic filing of all court documents in our FSD division, family division, civil division, and they're about to roll out in our Court of Appeal division. So we are live. We have firms who are filing all documents electronically. Nobody comes to the courthouse anymore. They do it online. We actually have litigants in person, likewise, who are able to open their accounts and file their court documents online. They can manage their cases through their own dashboard. I believe in this month we actually launched, or we're imminently about to launch, the pay module within the platform itself. Before people were filing, but then they'll do a direct bank transfer, which was a lot of work in the back end. But now they can file and pay on the platform itself. And we've also introduced what we call, it's probably not the correct word, but we call it a drawdown or escrow function, whereby, similar to what the General Registry has, when we know the firms, their attorneys are multiple users under the organization. So we have introduced a mechanism where they can provide us with a lump sum amount, and so their attorneys can do multiple filings, and they can manage that from the organization end of things. So we're making good headway. Where we are right now, is as at November 2022, we are actually doing data testing on migration. We are at the stage where we are ready to transfer data from the GEMS platform to the Curia platform, test the transfer and the mapping, and then retire the old data, those portions of the old database, so that the cases can run entirely in the new database system. We are working with the developers. We have a domestic project manager who works with us, who is an IT expert, who is assisting us with making sure that we tackle problems, we identify risks, we can problem solve, and we have, quite frankly, the technical expertise to deliver each aspect of the database successfully. The big area to be built, which I anticipate will take the entire of 2023, is the criminal platform, part of the platform, simply because it is much more complex. The procedures in the criminal division is very different from in the civil divisions of the court. And on top of that, there are a large number of justice partners. I mentioned earlier that we had identified around 20 governmental and non-governmental justice partners, and we have engaged them through survey, and we're going to be having meetings with them, because one of the key areas that we have to tackle and address and have clarity on is how they engage with the courts. Not only in terms of what they file with us, but also the information that they may require from us in order for them to discharge their duties. One of the, I think, observations in the report was to ensure that our platform could easily interface with other public government platforms. And it is built, our platform is built on a modern foundation whereby you should be able to connect to other Microsoft-based platforms, right? So we are starting to have those conversations with entities like the police, who we anticipate will be our biggest justice partner, because there are many different divisions or departments in the RCIPS that not only would give us information, but would need to receive information. Something as simple as police records. That information originates with the court, because we are responsible for the disposals. You know, right down to the end of life of a case where you have to dispose of evidence after the case has completed. So it is something that we are working on. We also have to be mindful of the legislative schemes and procedures that we're bound by, and there may need to be some revisiting too of our legislation. just to make sure that the procedures can flow better. But we are working to that end. There is a magistrate designated who is a member of the judiciary. I am involved. We have already invited the Director of Public Prosecution to get involved early, and we have written to the RCIPS, and the Commissioner of Police actually has already provided me with the names of committee members from his branch. So we are moving, I think, in earnest on the criminal side, but we recognize it's going to be complex, and we also recognize that it will impact tremendously data protection rights. So certainly our office has already been in consultation with the data protection persons in government so that we can incorporate all of these things when we build that portion of the platform. So I believe that if all goes well and we get the engagement that we are hoping for with our justice partners, that we should be able to see different modules in the criminal division come online sequentially. That's how we'll have to roll it out. It doesn't just roll out in one day. You roll out, for example, your quick wins, areas where you can have quick wins, like the coroner's court, maybe the rehabilitation courts, the mental health court, the domestic violence, and then you see your more complicated courts you roll out, perhaps at last, because it takes a lot more work to deliver those modules successfully.
Thank you, Ms. Bothwell. Certainly, we understand the monumental task that you all have in front of you in terms of placing an IT system. But while you gave a pretty comprehensive answer, I still didn't hear you say when is the expected completion date for all of that.
So for the criminal module, I'm expecting us to at least be live for most of the modules in 2023. I cannot guarantee it will be 100% finished, because certainly the work that will be done through the Core Excellence Framework, particularly I think on the area of analytics, we would have to be running a parallel exercise looking specifically at how we do costings and all the different measurements, because it's an ongoing process. We have the base platform for the analytics, but we still do need to continue to build on that. And so certainly I believe that the framework exercise that Chief Justice is starting will help to inform the direction we go in terms of customizing that part of the database. And I cannot say in earnest whether by January 24 we'll be done and dusted with everything. I think we will have an operational database, but it may require some level of fine-tuning, I suspect, in 2024.
Thank you for that, Ms. Bothwell. So, just to paraphrase, January 2024, you expect to be finished, but there may be some other back-end work that needs to be done to make it operational in the way that the court wants it to be.
Yes, I think we'll be functional in the sense that our criminal division would be operational in the Curious system from our in-house staff perspective and our major external stakeholders, because we, in addition to the internal part of the database, we also have to build modules for our external stakeholders to file, like what we have in the civil side. But because of the data sharing that might have to take place, it might be a bit more of a complex exercise, because we do have to find out what exactly do you need, you know. But I am confident that we will be making very good progress in 2024 on the criminal side with a view to retiring fully the GEMS, because that's the major thing. We need to retire GEMS and bring our data from GEMS into Curia, and that's a priority for us for the entire court.
Thank you, Ms. Bothwell. As you have detailed, the project is quite large to replace the IT system, and I suspect that you guys have encountered some problems. Can you say whether the judicial administration has a change management plan, a risk register, and success measures for the new court database that you've so eloquently described there?
Right. Through you, Mr. Chairman, I can confirm that starting off, we have something called a project charter, which is an agreement, not the contractual agreement, but almost like the procedure agreement between the Curia company and the courts, and it covers areas such as deliverables, milestones, areas of risk, and so forth. So that's a sort of top-level document that we have. We've all signed off on it, and we're working from that. There is a change management plan that was developed in consultation with our project manager for the project. I do believe, however, it does require some updating because some time has passed. There have been some delays, and we do actually have an ongoing template for any date milestones that we're to deliver, and if there are issues, there are regular meetings, and those things are negotiated and discussed between both sides. As for the risk register, I can say that we did have a trained staff member. I say did because she has quite successfully been promoted to another post in government. But we do have somebody who is responsible for managing the risks, and this is one of the projects that we've asked to be managed. We are aiming to do that, or we have been aiming to do that through an overarching standing committee that we've created for all projects, IT projects. So we are managing risks, but certainly with the changeover of staff, that is something that I am working with the new manager for us to kind of reassess where we are constantly. So for example, we are right now with the data migration on the non-criminal side. And that is something that is actively being managed, and we are managing that through a risk register. And we will continue to monitor various areas of risk. I have to confess that risk management is fairly new to government, and certainly fairly new to my office. I have done some initial training, but we do have quite a capable accounts department and some accountants in our organization who are helping us, and certainly we, along with our project manager, we are actively managing the risk through the register.
Thank you, Ms. Boswell. Ms. Bothwell, I'm just going to move on to the section about electronic traffic ticketing systems. And again, based on the 2019 Auditor General's report and how it highlighted the way traffic tickets and traffic offenses were processed through the courts could be improved. I suspect that this new IT upgrade would assist with that somehow. And you did state that there was a need for another solution to deal with the traffic offenses as the case going to the traffic court was significant, and I suspect from 2020 to now it has probably risen significantly. So can you give us an update on that system, including, if you haven't as yet, a target date for its implementation?
Through you, Mr. Chairman. So even though the court is the place where traffic tickets are paid, and if someone ends up not paying their traffic ticket on time, the ticket acts as a summons and they are to appear in the court. The court is not exactly the owner of the management of traffic-related matters. Sounds quite peculiar, but it's actually the fact. We process matters that come before the court. So the area of innovating the way traffic tickets are delivered, we have a consultative role. I can say that the Commissioner of Police and my office have had ongoing discussions on two fronts. The first being, what can we do as a placeholder to make the lives of our clients better and also our lives better, and to bring about internal efficiencies between our two entities in trying to deal with over 10,000 traffic tickets. Very discrete inroads have been made. For example, judicial administration of its own initiative decided to create our own pay module and allow clients to pay online through the website, even though we do not yet have the traffic ticket. So it is an element of trust between us and the court users, but I must say, to a large extent, a significant extent, it has been working very well. And it has been a tremendous convenience to the court user and to us. But it doesn't solve the problem. We are at early stages with the RCIPS to see if there can be a data sharing arrangement between our two entities whereby they first enter the traffic ticket details in their system. And then we get the ticket and we have to enter the second time. So we are working with them to see if there's a way in which when they enter it, it can just come into our Curia system directly. There have been a few challenges, so that has not yielded the benefits that I hoped it would yield as yet. The silver lining, I hope, is that I have been approached by Mr. Tristan Hides of the Ministry of Plahi. We had a meeting earlier this year because my understanding is that the camera system, the traffic camera system with the license plates, that system has the capability of introducing electronic traffic tickets. So we had an early discussion with him as a stakeholder, his office. I understand that a business case is being prepared by that ministry, and our key staff members have engaged with his office to provide any information requested to help inform that business case. I understand that there also will be meeting with the RCIPS, and our team have asked that before the business case is finalized, that there is a final meeting with all stakeholders to make sure that they are able to capture all of the relevant information. So we at Judicial Administration are eternally hopeful. We are ready. I believe that where we have reached with our new database, if a new platform for tickets is introduced, we can connect to it almost instantaneously. So we are eternally hopeful that some meaningful progress can be made on that front, because the honorable member is correct. Traffic tickets is a source of revenue. It is a tremendous source of revenue for the government that comes through the courts, and it requires, unfortunately, in this day and age, a tremendous amount of human resources, both for the RCIPS and the courts to administer, where I believe electronic traffic tickets is a very good example of how technology can bring about remarkable efficiency and effectiveness in delivery of services. And I would even go as far to say cost savings, because really and truly, who are the people that you need to be entering data if the data is already there from the point of the police's tablet? Yeah. So eternally hopeful, sir.
Ms. Bothwell, thank you so much. That's all the questions I have for you for now.
Thank you, Mr. Rankin. We're going to move now to the fourth area of questioning, and that is the new court building, the old Scotiabank building. And for that, I'm going to turn to Ms. Heather Bodden to lead the line of questioning. Ms. Bodden.
Thank you, Mr. Chairman. Good morning, Mrs. Bothwell. Thank you for joining us this morning. The Office of the Auditor General's 2019 report highlighted the importance of a new court building that meets the needs of all stakeholders involved in processing cases through the courts. In November 2019, Judicial Administration committed to engaging with stakeholders about the design of a new court building by April 2020. However, the engagement has not yet started 3 years later. We also note that you have not provided a new date for completing the stakeholder engagement. This essential information also needs to be factored into the online business case for the new court building. My question to you is, can you provide an update on the timelines for updated stakeholder engagement for the new court building, including start and finish dates?
Through you, Ms.
Before you answer, ma'am, I was totally mistaken. I think you picked up on that because I mentioned the Scotiabank building, but we're talking about the new court building. So.
Yeah, she knew.
Through you, Mr. Chairman. Regarding the specific recommendation, it was taken on board. I do recall that when we had the hearing before the last chairman of the PAC, we did share with the Auditor General's office some stakeholder engagement that took place at the beginning of the project. But naturally, we understand that that is dated and quite a bit of time has passed. In 2019, we did meet with the outline business case team led by PwC regarding this issue, and they were happy to move forward with additional stakeholder engagement. We do in our budget actually have funding for the exercise. We've costed it, but it has not taken place as yet for a few reasons. The first being that when the decision was taken to actually build the Grand Court, because we were short of actual spaces to hear Grand Court cases, and also the Court of Appeal, because the Court of Appeal actually has no courtroom of its own. The OBC team have stepped down until those projects were complete. So we have had, they're placed on hold until those projects are complete. Effective 2 weeks ago, those projects are complete. I have already spoken, I think in 2020, we're in 2022. So yeah, this year I've already spoken to the representative of PWD so that we can start that project. We were hoping to do it this last quarter, but with the Privy Council coming, we have not been able to start it. So we do have a proposal. I'm expecting that that's probably one of the first things we will lead with in 2022, to do an updated stakeholder engagement and an assessment on accommodation needs for the whole of judicial administration, and that will inform the wrap-up, quite frankly, of the business case, because the business case is in draft. It needs to be updated and wrapped up. So I expect it to be done, I would say, before summer of next year.
Thank you, Mrs. Bothwell. I would just like to ask if you think this additional space will provide the court with what has been desperately needed.
Through you, Mr. Chair, I recognize that the members have not had the benefit of seeing, or some of the members have not had the benefit of seeing the draft outline business case, which was in fact presented to caucus a few times. The procurement of the Old Scotia building was seen as part of a much bigger plan. And so the purchasing of that 4-story building was not meant to, in any way, to address the full accommodation needs of the court. There are some recommendations coming out of the report regarding our existing accommodation and how fit they are for our current need purposes. And certainly moving forward, there will need to be some assessment as to what the courts actually need. The Auditor General was correct in her assessment about what was driving the outline business case, the accommodation needs and the stakeholder input versus the proposed budget at the time that was discussed, and to what extent it actually met the legitimate needs of the court. So those things, the assessment will inform the final report. To what extent it will address affordability, at the end of the day, that will be for the government to decide. But we are aiming for before summer next year.
Thank you, Mrs. Bothwell.
Mr. Chair.
I did have Ms. Conley first, and then you can take it after.
Thank you, Mr. Chairman. Just a question, Mrs. Bothwell, on the new court rooms. I know you mentioned in the Scotia building you have new courtroom number 8 and number 9. Are you still holding court in the town hall as well as in the Kirk building? Is that still occurring?
Through you, Mr. Chair, yes. With respect to the town hall, I believe we use it 4 days a week, if not 5. It could even be 5. So we do, unfortunately, treat that space as a full-time space for the court. With respect to Kirk House, we have 4 open court hearing rooms. We have a courtroom 4 on the ground floor, which is quite small. We have a small court called courtroom 7. 4 in the ground floor. Courtroom 5 is our big court. It's on the 2nd floor, and that is where we tend to hold a lot of our big commercial cases or big criminal fraud cases. It is not really at the standard it should be for those types of trials. If one just looks at what has been done with the new court spaces, it becomes evident that it's not quite fit for purpose, and it raises a fundamental question about to what extent should the organization continue to invest quite heavily in a building it does not own. and also a building which cannot take the full gamut of cases that it will be need to hear in its courts because of the way that Kirk House is structured. We cannot address very core security needs for that building. So therefore, the ability to hear custody cases in that building is highly limited. So we are restricted right now to the main court building because we have cells there. There are no cells in Kirk House. So the grand court that we built on the ground floor, we have built cells, small cells in there, which alleviates the pressure that we have in the main court building with the two main courts that are tied to the cells. We also have courtroom 6, which is on the 3rd floor of Kirk House, and that functions primarily as a financial services court. It is not very large, and sometimes these cases can have multiple parties, multiple attorneys. Sometimes the accountants are there. So certainly it's about not just having a space, but having a space that is needed for you to deliver services. And these are the things that the accommodation needs assessment will address. Right, I can't remember the question now. Yeah, so yeah, Kirk House, that's it. Yeah, and then so courtroom 8 will address some of our criminal court needs. Courtroom 9, which is the newest court, we just got our certificate of occupancy last week. That was where the Privy Council sat. That is to be the home of the Court of Appeal. The Court of Appeal are currently here and they're sitting there. They sit for 9 weeks out of the year as a minimum. However, they do have special sittings, which means that they can come back to Cayman multiple times for the year to hear various matters which could either last days or weeks. So the fact that they actually have their own space now will help because it means that we will not be kicking them out, kicking another court out so that they can utilize their space. So it will alleviate some pressures. But yeah, the existing court arrangements are far from being satisfied.
Thank you, Mr. Chair. Obviously, the court is very important to this country or any country. And I'm trying to help here because I see and I note that I remember was a part of the administration when this new court building was approved, the purchase of the old Scotia Bank, and very excited about the new parking garage that was going to be there and the extended heights of a new courthouse. Couldn't wait to enter it, not to be charged, but just to visit. But what my question is, what is the actual structure of your office? Because I sense that, I mean, just by some of your explanations, they're quite comprehensive, and just seems like you have a heavy workload, and I am very concerned as to what structure you have there, and if there's anything that we need to do to assist with this.
Through you, Mr. Chairman, the work of the court administrator, I would say perhaps is not too different from the work of my colleague, the Clerk of Parliament, where everything is for you to do. And you may not have necessarily the appropriate leadership structure to support you in the beginning. I've been in post for 6 years, and it has taken me all of 6 years, I would say, to identify some of the core needs, particularly at the leadership level, in order for us to be able to successfully deliver some initiatives of the court in a way that would be beneficial to the country and to the country's resources. So when I went into post, I had no deputy chief officer, even though I was called a chief officer under the Act. So I technically had to rely on the clerk of court to cover for me, whose role and function is very distinct and quite full in its own right. We continue to share finance services with about 8 government entities. However, we have revisited the structure of our finance department. We got some external guidance on some of the benchmarks that we should be hitting as an entity that handles cash and manages money. And so I have been working with the CFO to implement those structures and those government best practices to ensure that we have robust financial management of the significant funds that the court receives or holds in trusts. So we do have a financial controller who actually sits at the court, who is a very experienced qualified accountant, and a deputy financial controller. And that allows the CFO to be in her remote location. We are currently at the point of separating and having our own CFO, because we are by far the largest entity that CFO covers, and it warrants its own management, full-time management. So that is something that we are working through now. We have started working on workforce planning. We are mindful of the recommendation of the Auditor General. I read the Auditor General's government audit on workforce planning for the entire civil service, I believe. We did try to start the initiative last year and to identify resource materials and to see how we can do it in-house. But I think we quickly realized it was beyond our capabilities. So we have decided, and we are currently working on a business case to see how we can procure some technical expertise to help us with such an exercise, to go through the workforce planning for the administration and the judiciary, because I do believe at the end of the day it will tie in to the accommodation needs and also the business of the court from the perspective of any sort of performance initiatives that we introduce moving forward, and for us to also look at where our efficiencies can be achieved in our current business processes, and also in terms of our staffing. So I do agree that it is a worthwhile initiative. I'm no expert in workforce planning, so perhaps it was naive of us to believe we could try to do it ourselves and not understanding the extent to which we might need to have some help. I did obtain a lot of guidance documents from other entities that I know, not in our government, but otherwise that I saw that did the exercise. But I believe that because we also interface with the work of the judiciary, there might need to be a much more comprehensive analysis of really what our workforce planning needs are as a whole.
Mr. Chair, I really thank Mrs. Bothwell for that answer, and that supports my belief that, and well, I guess the additional, I just want to know specifically then, there's a chief officer and there's a deputy?
Yes, so what I can say is I do believe in earnest at this time the administration has the staffing at a leadership and executive level to effectively run the business of the court and to support the Chief Justice and the judiciary. We've implemented some key posts, and I do see a change, a positive change, in terms of the way in which we are able to deliver and the timeliness. There are other areas that we still need to look at. We have gotten some feedback, for example, that the courts, like other courts, should introduce like a communications officer, because we need to ensure that we have centralization of communication. We have a lot of records management in the courts, and the Chief Justice, Sir Anthony Smelly, before he left, he did introduce a new, quite a significant practice direction, opening the doors of access to criminal court records. And so that puts an entirely new color on our disclosure procedures. So, but these are discussions that I am sure that I will have with Chief Justice Ramsey Hale, and I am sure that the workforce planning exercise will inform these discussions as we move forward.
Mr. Chair, I thank you, Mrs. Bothwell. In my humble opinion, and I would suggest that an external professional company or organization come in and undertake this study, because just in itself, as Ms. Bothwell was just saying, in terms of record management, communications, even project management, because of the fluid situation in terms of the court, in terms of increased cases, etc., as to, you know, the needs. I mean, what I'm thinking is I don't still understand the full structure, because it seems like there's a lot of moving parts there and a lot of different areas that are covered by different people. And, you know, what I'm kind of suggesting is like any other ministry that they have either two deputies, and that and one deputy could be looking at matters in terms of projects. They'll be for many years build out of new properties and new buildings, and you know, that same chief of deputy could be in charge of other things and free up Mrs. Bothwell so that she can concentrate on some of the things that are taking so long to be completed. And I say that with all respects, that I appreciate that she does have a heavy workload.
Thank you for that. Other questions then on this area? Okay. If there are, then the final area was on workforce planning, which I know Ms. Bothwell, she touched on it. Okay. Ms. Heather, I think you had some further questions, right? No? Okay. Ms. Conley, you have any other questions then on the workforce planning?
Thank you, Mr. Chairman. Yes, I do. Through you to the witness. The Auditor General's 2019 report stated that senior managers in the judicial administration consistently raised the lack of staff as an issue affecting the efficient operation of summary courts. However, judicial administration had not performed the workforce planning to determine how many staff it needed and with what skills to operate effectively or efficiently. Therefore, the Auditor General recommended that judicial administration develop a workforce plan to address these concerns. We note that you accepted this recommendation, but 3 years later, no progress has been made. And I know you mentioned regarding the workforce and your staff. However, can you say what progress has been made in developing a workforce plan and the target date for finalizing the judicial administration workforce plan?
Through you, Mr. Chair. So we are working on a business case now. As I indicated in my earlier response, we were preparing to do it in-house. I have a chief HR officer, and the feedback I received was that most likely we can do this in-house. So when we started the work, the initial exploratory work, it became apparent to me that actually I didn't think we could do it in-house. So I have asked that we actually do a business case. I have already spoken with the new Chief Justice because there is a transition to be had, and I would have to debrief her on everything really. And I have already raised this with her as something that's important, and she also recognizes the importance of getting out very quickly a workforce assessment. So we are working on it. I expect that we would have the draft document before the end of Christmas, and that we can go out for procurement in January. Of 23. Sorry.
Through you, Mr. Chairman, to the witness. Thank you for that explanation. So currently, as we stand as of today, are you satisfied that you have enough staff to carry out all the work that's necessary in the judicial administration?
Through you, Mr. Chair. We have been able to tackle some of the hotspot areas in some of our registries, particularly in the criminal side. One of the things that I did ask the managers to do was to see how the business processes were either helping or harming staff. And so they did take a look at that to see how we can better streamline the business and segregate duties. Where I think before we can make really good inroads as to what our workforce needs are, particularly on the criminal side, we would need to have a clear understanding of the efficiencies that would be derived from the introduction of the new court database. Because it's not just about building the data, well, it's partly the database itself in that instead of taking 5 steps to do one thing, you might take 2, so you can cut down on processes there, but also to some business decisions regarding, for example, in other jurisdictions, you have data entry in the courtroom itself, and the potential elimination of court files, paper files, that would allow everything to be generated in a paperless environment. And because those things themselves cause, I don't want to say the word inefficiency, but they cause additional work. So right now, I do believe that the pressure is managed with the staff, and we do have the basic resources to meet the current processes that we have. But certainly, I do believe that with all of the different things, that there is an opportunity for re-engineering the way we do our business in that division. That would have to be done, of course, with the input and direction of the Chief Justice and the judiciary. But I do think that there are opportunities to actually redeploy staff in different areas, quite frankly, so that they're not doing the same thing. I give you a very, very real example of this. I'd never had an executive officer who was only dedicated to entering traffic tickets. It never existed. But I was forced to find the funding and to convert a post to create that new function because of the errors that were happening in the department, because just the sheer volume. It is one of the most monotonous tasks that anybody can do, and it resulted, unfortunately, in us really unfortunately disenfranchising some of our court users, and we had to deal with that. However, in order to address the problem at hand, I had to hire a temporary staff member to take over the responsibilities, take an existing vacant post and convert it just so that person can enter traffic tickets for a second time, because the first time is at the RCIPS. Hence my discussion before. So when I say I think that there are real opportunities for redeploying and creating efficiencies, I really do mean it, because if we can get all of these mechanisms to work properly, it will cut out a lot of the existing paper-heavy functions that we have at the courts. We're making inroads with the e-filing and so forth, but we do have a long way to go. The staff are managing. The staff are managing.
Ms. Bothwell, do you have anyone that sort of operates at a chief operating officer level in your organization?
Through
Listening to you here this morning, it just strikes me as something I think that could be quite useful to you in terms of the administration work. I mean, I hear all you said this morning,
yeah,
and I recognize some of the challenges that you do face. But I mean, just simply, do you have someone at that can operate or does operate at that level? Or because I think it would be a resource that could be extremely helpful to you.
Through you, Mr. Chair, or Mr. Chairman, sorry, we do not have a dedicated person. What we have done is, in extreme circumstances, we've gotten some kind of external consultant to help us to identify where the problems are and to see if we can have efficiencies. We did that with our finance department, and I'm happy to say that that department is probably like 90% paperless. We process almost every single thing online, and we get our invoices out quite quickly. You know, that's a good example of success by re-engineering our processes. The other departments know, because it is very difficult, I think, to get someone. They won't have anyone on island who can come into our court system. They have to learn the court system first and then figure it out. But I do believe that there are people who can say, well, you're doing this 2 or 3 times, and you might want to think about doing A or B or C. And right now it is only our managers, but we are still bound to some degree by court procedures, maybe some court rules. We are bound to some degree also by the limitations of our stakeholders, our external stakeholders. And, but I take on board your point, sir. I think it is something that if we're going to continue to look at the area of efficiency and effectiveness, we need to have people who can help us run our numbers. I'm aware, for example, in Jamaica, they are also doing the framework for court excellence, that they've also adopted the expertise of statisticians, and certainly looking at our business procedures would be one of those things, and also things like quality assurance. You know, how do we those are things that we do recognize that we must find a way to build into our operations. But right now we do not have a chief operating officer.
Thank you for that. Are there any other questions from members? Well, this concludes our session for today. Ms. Bothwell, I do thank you for attending. We've been at it all morning. It's been taken up quite a bit of time, but I think we do have a better appreciation too for the work that's undertaken and the tasks that you do face. And we thank you for being here this morning and sharing your thoughts and your giving us this update as well. So thank you all very much. To members of the committee, I thank you all too for being here and for your participation and for asking questions and querying our witness. Thanks to the Auditor General and her office and staff here as well, and to the Financial Secretary and the Accountant General for being here this morning as well. And also, as always, thank the parliamentary, what title? Parliamentary Clerk, I get it right, for your assistance as always in these hearings. So ladies and gentlemen, that concludes the session for today. We will begin again tomorrow morning at 10 a.m. when we are going to be looking at the Auditor General, another of the Auditor General's reports. So until then, have a pleasant day.
Mr. Chairman, I just wanted to make sure that the committee is aware that I will not be here tomorrow. So just wanted to recognize that others will be, but I won't be. Thank you, sir.
Thank you too, and we'll make mention of that tomorrow as well.